My name's Marwa Haddy. I'm a solicitor in the family law team at Rawlison Butler. One of the areas which our clients find most challenging is what the arrangements should be for the children when their relationship breaks down. This is understandable. So, at Rawlison Butler, we ensure we give you expert and practical advice. The first question a parent will often ask is, where will our children live? Ultimately, this is a question for you and the other parent to decide between you. Many parents find an arrangement that works for their particular family. In these cases, you possibly don't need to involve anyone else, but even then, it is often helpful for a parenting plan agreement to be drawn up in writing. This can set out how much time the children spend with each parent. This can also help make sure there is no confusion moving forward and can preempt any upcoming events where there may be a dispute, say for example birthdays and Christmas. Sadly, it is not always that easy for families to reach such an amicable agreement. You and the other parent may differ in what you think is best for the children. The two most common examples we come across is where both the mother and father want the children to live with them full time. And the other situation, which is quite common, is where although the parents have agreed who the children will live with, they can't agree as to how often the other parent should see the children. In those situations, it is sometimes a good idea to seek help from someone else. We often recommend that the parents attend a process known as mediation. A mediator is someone, often trained as a lawyer, who is completely impartial. They will try to help both parents in reaching an agreement regarding the children. Often, there will be a number of sessions with the mediator. Many couples who've been through the mediation process feel that this has worked quite well for them. It is often less stressful and costly than having to go to court. In fact, because of the benefits of mediation, the courts have now made it compulsory to have an initial meeting with a mediator before a parent can issue court proceedings. There are a few exceptions to this, but we can advise you on whether mediation is necessary in your case. While mediation can prove helpful, again, not all families find this resolves their particular issues. For example, one parent may refuse to attend mediation, or mediation could be attempted, but still no agreement is reached. In those situations, we can help you start the court process. We can help you apply for what is known as a child arrangements order. This is a court order which will set out who the children will live with and how much time they will spend with each parent. Sometimes you may find that the main arrangements, such as where the children will live, are agreed, but as parents you can't agree on other issues. For example, which surname the child will take, or which religion the child will be brought up in. In those situations, the court can make what is known as a specific issue order. So the court can make a decision in relation to that particular issue which cannot be agreed between the parents. The court can also make what is known as a prohibited steps order. Such an order can prevent the other parent from doing a certain thing. For example, moving with a child to another town. When deciding whether to make such an order, the welfare of the children will be the court's paramount consideration. The court also has a checklist of factors to consider. These include the wishes and feelings of the child or children concerned, considered in light of their age and understanding, their physical, emotional and educational needs, the likely effect on the child of any change in circumstances, their age, sex, background and any other relevant characteristics, any harm that the child has suffered or is at risk of suffering, and finally, how capable each of the child's parents are of meeting the child's needs. In making its decision, the court will often ask for the assistance of a Children and Families Court Advisory and Support Service officer, known as a CAFCAS officer. The CAFCAS officer will make their own recommendations, which the court may take into account. It is a common misconception that children will always live with their mothers. This, in fact, is not the case. The courts are moving towards shared parental arrangements. Other than in the most exceptional circumstances, it is considered in the child's best interest to enjoy a relationship with both their mother and their father. If you'd like to know more about what your options are regarding any arrangements for you and your children where a relationship is broken down, do contact the family team here at Rawlison Butler.